Hello, IP students. Today our topic is Society Law and Ethics, and this is Society Law and Ethics Part 7. In this lecture, we are going to discuss about some different types of software license. Some of them I've already discussed in our previous lecture, and in this lecture, we are going to discuss about BSD license, MIT license, and Apache license. So let us take them one by one. First of all, BSD license, basically known as Berkeley Software Distribution, BSD license. So what is BSD license and for what purpose it is used for? The BSD represent basically a family of permissive free software license that have few restrictions on distributions compared to the other free software license such as GNU, General Public License. So there is an important point here. It is a family of permissive free software license, and second thing is few restrictions here in comparison to general public license. Now there are two important versions of BSD license. First one is the new BSD license. It is also called as 3-clause license, and it allows unlimited redistribution for any purpose as long as its copyright notices and license and disclaimers of warranty are maintained. And second point regarding to this is the license also contained clause restricting use of the names of the contributors for endorsement of a derived work without specific permission. And the simplified second one is the simplified BSD license, free BSD license, also called as free BSD license. Basically, it omits the non-endorsement clauses. So the basic difference between the new BSD license or the modified BSD license and between free BSD license is that non-endorsement clauses. Basically, free BSD license omits the non-endorsement clauses, and the new BSD license or modified BSD license contain endorsement clauses. So this is all about BSD license. So few things are very important. First of all, BSD license basically represent a family of permissive free software license. Second thing is that in comparison to general public license, um, it provides few restrictions, and it basically can be BSD can be categorized into two basic categories: modified and free BSD license. Modified, also called as 3-clause license. First one is that it allows unlimited distribution of any purpose as long as its copyright notices and warranty are maintained. And second important thing is that the license also contains a clause of restricting use of names of the contributors for endorsement of a derived work. So, and the second is the simplified BSD license, also called as free BSD license, which omits the non-endorsement clauses. So the difference between endorsement clause. Next is MIT license. MIT license basically the shortest and the probably broadest of all of the popular open source license, and it is the least restrictive open source license. And the basic provisions of this license, basically there are three basic provisions. First one is you can use, copy, and modify the software however you want. Second thing, you can give the software for free or sell it. You have no restrictions on how to distribute it. And second thing, the only restriction is that it be accompanied by the license agreement. So these are the three important points regarding to MIT license. First one is you can use, copy, and modify the software however you want. Second is you can give the software away for free or sell it. There is a little bit spelling mistake in second point. Second point is you can give the software away for free or sell it, and you have no restriction on how to distribute it. And third point is the only restriction is that it be accompanied by the license agreement. And third license is Apache license. So the Apache's license basically grants a number of rights to users. These rights can be applied to both copyright and patent. And the basic features of Apache license are: first one is rights are perpetual. That means once granted, you can continue to use them forever. It means for lifetime. Second thing is rights are worldwide. So rights are worldwide. It means if the rights are granted in one country, then they are be granted in all other countries. Next point is rights are granted for no fee or royalty. So there is upfront uses free, no per uses fee, or any other basic rather either. And the third is rights are non-exclusive. It means you cannot the sole license, and other can also use the license worked. And last point regarding to Apache license are rights are irrevocable. It means no one can take these rights away once they are granted. So these are the some important points regarding to the Apache license. So these are the three different types of license, and in our previous lecture we discussed about GNU and also pronounced at GNU. So GNU General Public License, GPL and LGPL. So let us take a quick revision of GPL and LGPL. Basically, GPL is a free copyleft license for software and other kinds of works, and it is intended to guarantee your freedom to share and change all versions of a program to make sure it remains free software for all its user. Basically, there are some features of general public license, and these are: you can copy the software. Second is distribute the software however you want. Third is charge a fee to distribute the software. And last point is makes whatever modifications to the software you want. So these are the four basic or important characteristics of general public license. These topics are already discussed in our previous lecture, GPL and LGPL, since they are related to the software license. So I'm trying to give a brief description of GPL and LGPL. Second is lesser general public license. As the name suggests, lesser general public license. So it is basically similar to the GPL, but gives you a lesser restrictions regarding to that GPL. So this accompanies some open source software that details how the software and its accompanying source code can be freely copied, distributed, and modified. And the author of this license asks that you only use this license if you are licensing functionality already commonly available. And third point regarding to the LGPL is LGPL is used to license free software so that it can be incorporated into both free software and proprietary software. So GNU license, basically there is a common term known as the lesser general public license, and it offers lesser right to a work with the standard GPL license. Because it offers lesser right to a work than the standard GPL license, so that's why it is called the lesser general public license. So the difference between general public license and lesser general public license is that LGPL offers lesser rights to a work than the standard GPL license. So these are the important difference. Some important point regarding to LGPL. Basically, LGPL provides copyright protection. We can say that yes, it is a true statement, and it can be used in commercial application. Yes, it is also true. Bug fixes extension must be released to the public domain. Yes, it is also true. Fourth point: provide an explicit patent license. This is false. It is not um, provide a explicit patent license. And next point is can be used to proprietary application. Yes, it is true. And it is a wider license. Yes, it is also true. So basically the basic point regarding to LGPL is that it does not provide an explicit patent license. Next, now there are some important topic regarding to societal and ethics. So let us take a quick revision. Societal and ethics, first point is intellectual property right. Intellectual property right, basically the property created by so first is what is intellectual property. So intellectual property is basically property created by the application of human mind. So intellectual property is a term basically referring to a number of distinct types of creations of the mind for which property rights are recognized in the corresponding field of laws. And the articles concerned regarding to intellectual properties are textiles, cosmetics, pharmaceuticals, machinery, books, etc. And intellectual property right types of intellectual property rights are patent, copyright, trademark, design, database, and trade secret. And the important question regarding to intellectual property right is what is the difference between patent and copyright? And sometimes it also asked in examination that what do you mean by trademark? So patent, copyright, and trademark are three important topics regarding to intellectual property right. So let us take a quick revision of all these three topics. First of all, what is copyright? As the name suggests, copyright basically allows authors, musicians, artists, etc. to make money of their labor. It prevents other from taking their work for free. It also prevents people from altering the work without permission. So this is about copyright. Second is patent. Patent is an exclusive right granted by the authority to the applicant of an invention for a limited period of time. So that is important point, limited period of time. Always remember that patent is always for a limited period of time. And third is trademark. Is an emphasis that trademark. It is basically a distinctive sign which identifies the goods and services of one company from those of another. As there is a symbol of Coca-Cola here, so it is basically a trademark. And this is a trademark for Nike. Now, after combining all these intellectual property right, so the difference among all these in terms of who it serves. So trademark serves for brands, copyrights authors, and for patent inventors. So patent serves for inventors, copyright serves for authors, and trademark serves for brand. And what is the purpose of trademark? Basically, the purpose of the trademark is to distinguish product or service from competitors. And for copyright, it protects original creative and or intellectual work. And patent purpose is to grant exclusive right to exploit an invention. Example of trademark are words, logos, slogans, colors. Example of copyrights are music, arts, photography, and examples of patent are medical devices, technologies. And time limit. Time limit for trademark is basically not defined. It is unlimited or undefinite, and copyright is about for 70 to 170 years, and patent is for 15 to 20 years. Generally, it is 17 years. Next topic is plagiarism. So what is plagiarism? Plagiarism is basically stealing information of someone else, is also known as plagiarism, and it is a type of cybercrime, and it is very important topic regarding to society, law, and ethics. So plagiarism is using another person's ideas in your writing without giving credit to that person. So as I told you earlier, that stealing someone's ideas is also called as plagiarism. So in other words, plagiarism is copying information and not giving the author credit for it. So if you copying information of someone else and not giving credit for its author, then it is also called as plagiarism. Next is regarding to the plagiarism definition. Plagiarism is an act of stealing someone else's creativity, ideas, or language, and it is considered to be a cheating and a corrupt act. In advanced countries with high standard of education, plagiarism is considered to be an academic crime, and but it offers goes unnoticed in some countries, including Cambodia. So plagiarism is basically a cybercrime. and it involves stealing someone information without giving credit to its author. And in most of the countries, basically advanced countries, it is considered to be an academic crime, but in some countries, um, like Cambodia, it is not considered as a cybercrime. So it is illegal and unethical. Next important topic is spoofing and phishing. So these are the types of some cybercrime. So basically, spoofing is a part of phishing. So what is phishing? In which hacker tries to steal the sensitive information of the user, and in spoofing, hackers try to steal the identity to act as another individual. And always remember that spoofing is a part of phishing. But if asked in examination what is the difference between spoofing and phishing, then you can specifically mention the difference between spoofing and phishing. So in phishing, hackers tries to steal the sensitive information of the user, and in spoofing, hackers tries to steal the identity to act as another individual. Second point is regarding to phishing is it is operated in a fraud manner, and in spoofing it does not require any fraud. In phishing, information is theft, but in spoofing, information is not theft, identity is theft. And in phishing, hackers tries to steal the sensitive information of the user, and in spoofing, hackers tries to steal the identity to act as another individual. And in phishing, it is operated in a fraud manner, and spoofing, it does not require any fraud. Next, phishing cannot be a part of the spoofing, and spoofing can be a part of the phishing. No, so that is the basic difference between spoofing and phishing. Spoofing can be a part of the phishing because in spoofing, basically there is identity theft, and in phishing, um, basically there is information theft. So we can see that spoofing can be a part of phishing. It is not essential that always spoofing is a part of phishing, but it can be a part of the phishing. But phishing cannot be a part of the spoofing because those two terms are different to each other. In phishing, there is a theft of information, and in spoofing, there is a theft of identity. So, in identity theft, it may be possible that some information can also be theft, but in phishing, only the information is theft. So, identity is not concerned about phishing. So, phishing may be a part of, can be a part of, can be part of. Spoofing can be part of the phishing, but phishing cannot be part of the spoofing. Second important point, spoofing needs to download some malicious software in the victim computer, such as Trojan horse. So spoofing is basically done to get a new identity, and phishing knows such malicious software is needed. Phishing is done to get secret information. So the most important point is that phishing is done to get the secret information, and spoofing basically done to get new identity. So that is the basic and the most important difference between spoofing and phishing. So if if you have to write answer in only one line, then you can say that phishing is done to get secret information, and spoofing is basically done to get a new identity. And second, and the most important point regarding to spoofing is that spoofing can be part of the phishing, but phishing cannot be part of the spoofing. Now, the last point regarding the phishing is spoofing. Types of phishing: phone phishing, clone phishing, and types of spoofing are IP spoofing, email spoofing, URL spoofing. These are the types of spoofing. Next, cybercrime. This is a very common term, cybercrime. What is cybercrime? I think all of you are very familiar to the term cybercrime, and it is also a very important topic. Cybercrime and IT Act 2000 and 2008. These topics are already discussed, so here I give you a little um, description about cybercrime. The US Department of Justice, DOJ, divides cybercrime into three categories. So cybercrime basically have three categories. First, crime in which the computing device is the target, for example, to gain a network access. Second, crime in which the computer used as a weapon, for example, to launch a denial of service attack, also called as DOS attack. And third, crimes in which the computer used as an accessory to a crime, for example, using the computer to store illegally obtained data. And these are the types of cybercrimes in which we already discussed some of them in this lecture: phishing and spoofing, and unauthorized access, web hijacking, pornography, child sexual abuse, SaaS stalking, software piracy, salami attack, service attack, virus attack, phishing. So all these are the types of cybercrimes. As far as syllabus is concerned, phishing and spoofing are very important topic regarding to exam. And last important topic is hacker and cracker. These are basically two similar terms, hacker and cracker. So there is a little bit difference about hacker and cracker. Basically, as far as the definition is concerned, a hacker is a person who is interested in the working of any computer operating system. Most often hackers are programmers. Hackers obtain advanced knowledge of operating system and programming language, and they may know various security holes within systems and the reasons for such holes. And for cracker, a cracker is a person who breaks into other people's systems with malicious intentions. Crackers gain unauthorized access, destroy important data, stop services provided by the server, or basically cause problems for their targets. Crackers can easily be identified because they are because their actions are malicious. So we can say that crackers have malicious intention, but hackers doesn't have malicious intention at all. But hackers have good knowledge of operating system and programming, and crackers basically use unauthorized access and destroy the important data because they have malicious intentions. Second important point about hacker is that hacker constantly seek further knowledge, share what they have discovered, and they have never have intentions about damaging or stealing data. So that is a very important point. As I told you earlier, that hackers have no malicious intentions. So basically, they um, hack the data for um, only of their interest and for their knowledge. And for cracker, they have intention about damaging or stealing data. Hackers, they does not work against the law, but cracker, they work against law. So basically we can say that crackers are criminal. And the last point regarding to hacker is that they are always find weak points of the applications or website, and they secure it. And crackers, they have always bad intention whenever they work. So the difference between hacker and cracker is basic difference, or we can say that the difference mentioned in one line, that crackers are those person who have malicious intentions, and hackers doesn't have basically malicious intention. They hack the data for their knowledge, or seek for the knowledge, or um, share what they have discovered. So this is the difference between hacker and cracker. And this is the last topic regarding to societal and ethics. So let us take a quick revision what we have read in this learned in this lecture. Basically, license. So three types of license are there: BSD license, also known as Berkeley software distribution, BSD license. So BSD represent a family of permissive free software license. Note down that: permissive free software license, and they have few restrictions in comparison to general public license. So that is the first important point. And second important point is that um, there are two different or two important versions of BSD license. First is modified BSD, or second is free BSD license.
Modified is also called as three clause license, and it allows unlimited redistribution of any purpose. And second is, the license also contains a clause restricting the use of the names of the contributors for endorsement of a derived work without specific permission. And the simplified BSD license, it omits the non-endorsement clause. So the difference between these two is, basically simplified BSD license omits the non-endorsement clause, and in new BSD or modified BSD license basically allows or unlimited redistribution of software. Second is MIT license. So MIT license basically is a least restrictive open source license, and in using MIT license you can use, copy and modify the software however you want. You can give the software for sell it, and the only restriction is that it is accompanied by the license agreement. As I told you that there is some spelling mistake in MIT license in point number 2. So point number 2, you can give the software away, for free or sell it. Third is Apache license. The Apache license grants a number of rights to users, and these rights can be applied to both copyright and patent. And rights regarding to Apache license are basically there are 5 rights, and as you see that screen, the only 4 are mentioned. First, rights are perpetual, means once granted you can continue to use them forever. Second, it's right are worldwide, so it is not written, rights are worldwide. You can note down worldwide. Rights are worldwide. And what is the meaning of this term? Rights are worldwide means it is a right. If the rights are granted in one country, then they are granted in all other countries. And second point is, rights are granted for no fees or royalty. Rights are non-exclusive. It means you cannot, the sole license other can also use the license work. And fourth is, rights are irrevocable, means no one can take right away once they are granted. General public license and lesser general public license are already discussed in our previous lectures. So the basic differences between general public license and lesser general public license is that lesser general public license basically offers less rights to a work than a standard GPL license, and a standard GPL license or general public license basically provides 4 types of functionality. You can copy the software, distribute the software however you want, charge a fees to distribute the software, and fourth is make whatever modifications to the software you want. Next is intellectual property right. So there are 3 important intellectual property right: patent, copyright and trademark. You have to learn this chart because it contains all the definitions, its purpose, examples and time limit. And plagiarism basically is stealing information of someone else without giving credit to author. And spoofing and phishing basically steal hackers tries to steal the sensitive information, but in spoofing hackers basically tries to steal the identity. Spoofing can be a part of phishing, but phishing cannot be a part of spoofing. And third important point regarding to spoofing is that spoofing needs to download some malicious software in victim computer, but in phishing no such malicious software is needed. Next is cybercrime. Cybercrime basically the definition of cybercrime given by US Department of Justice, and contain 3 important points. First, cybercrimes are the crimes in which the computing device is the target, for example to gain network access. Second, crimes in which the computer is used as a weapon, for example launch of denial of service attack. And third is crimes in which the computer is used as an accessory to a crime. So these are some types of cybercrime: phishing, cyber stalking, salami attack, pornography, web hijacking, unauthorized access, virus attacks, service attacks, child sexual abuse. These are all types of these are the types of cyber crimes. And hacker and crackers, basically the difference between hacker and cracker is that cracker is a person who breaks into the other people's system with malicious intentions, but hackers have no malicious intention. So only the difference between hacker and crackers, if we want to say in one line, that intention: crackers have malicious intentions, or but hackers don't have any malicious intention. They basically hack data for their knowledge, and they are not basically trying to damage or stealing data, not trying to damage or stealing data. So these are the difference between hackers and crackers. Thank you for watching this video.